welcoming everybody here tonight is one of Lobby's pleasures because we have our seminars throughout the year. And today we have representatives of the Romanian Embassy, the Greek, the Cyprus Embassy, and members of our community associations, as well as from academia, and plenty of lawyers, I understand, today, as well as others from the oil and gas industry. Lobby for Cyprus has at the back a lot of the materials. We have published quite a few books, and please go to the back, have a look, and if you can support us by donating some money towards anything that is of interest to you, we would really highly appreciate it. We also now are trying to become far more technologically orientated by using Facebook and Twitter. So we would appreciate any of you that do have Facebook links and Twitter to actually, they say, tweet us and go on Facebook as well, please. That would be tremendous support, and Christos, who is involved in our designing and inputting the information, would highly appreciate that. Lobby will be having a further seminar in April, and that seminar is going to be focused on property. And in particular, everyone has been talking about or has heard of the IPC, the Immovable Property Commission. So we are planning to have a seminar on this issue, very topical, and I would like to invite you all in April, and we will be sending through invitations very, very soon for that seminar as well. I'm now going to pass you to Kostas Frangaskidis, who will be chairing tonight. Kostas is in the executive of Lobby for Cyprus, a lawyer, a partner in a firm here in London, Hoffman, Fenwick and Whelan. Kostas, over to you.
Theo's made my introduction, but I'm more importantly going to introduce our speakers, two eminent speakers we have tonight. Dr. Klearchos Kyriakidis, a senior lecturer and non-practicing solicitor at the School of Law, University of Hertfordshire, England. Dr. Kyriakidis will discuss related issues arising from the discovery of natural gas in the exclusive economic zone of the Republic of Cyprus. And of course, Klearchos will give us his thoughts, as he always does, on what this means for the Cyprus issue. And I'm sure that will be a very interesting and informative talk. We're also very, very pleased indeed to have from Athens, he arrived this morning from a very cold Athens, Stratis Georgilas, a member of the Athens Bar and head of chambers at Georgilas and Associates, Law Chambers Athens, who will consider the discovery of natural gas in the context of an analysis of rights and duties of states under the law of the sea, the exploitation of offshore resources by or on behalf of a state, and the settlement of disputes in accordance with the rule of law. Now, before I pass over the speakers, I just want to say a bit about Lobby and Lobby for Cyprus. Lobby was formed 20 years ago, well, nearly 20 years ago, so the Greek Cypriot refugees who had been expelled from their homes following the Turkish invasion of Cyprus in 1974 had a voice. Lobby for Cyprus was formed after the invasion of 1974, 20 years ago, so that the Greek Cypriot refugees had a voice, and a voice which was not dependent on any political party or government position. We are strictly non-party political here. Our message and our objective is straightforward. The invasion and occupation of Cyprus in 1974 was illegal, immoral, unethical, and in breach of international law. However, after more than 38 years, the Republic of Cyprus is still occupied and the island and its people divided. We at Lobby will not give up. We believe that Cyprus should be united, and we believe in what we call the 3 R's. These are the cornerstone of our philosophy and principles, which every Cypriot, regardless of party political affiliation, should agree with. The return of all refugees to their homes, the repatriation of the Turkish colonists sent to change the demographic structure of the island, and the removal of the 50,000 or more Turkish troops which still occupy the north of the island. Nicosia is the last divided capital city in Europe. This is obviously a disgraceful state of affairs. We must speak with one voice and demand that Turkey respects the human rights of both Greek and Turkish Cypriots and respects international law. And turning to the issue of law, of course, we at Lobby believe, support and uphold the law and have supported many cases fought on behalf of the Greek Cypriots which have been successful and have redressed some of the balance. But of course, after 38 years, Turkey remains in occupation. So one of the questions, and I'll leave you with this thought and issue tonight, of course, is whether the Republic of Cyprus will be able to exploit its gas resources for the good of all Cypriots, and whether the law of the seas will be upheld. Is this really a game changer? I will now pass over to Stratis Georgilas, who will start tonight.
It is a privilege and a pleasure to speak before an indeed intellectual audience at the premises of this cultural institution whose well-established and exceptional reputation has reached grim Athens. While closely following the current situation in the eastern part of the Mediterranean Sea, I trust one should always keep a watchful eye on some long-rooted issues prior to their metamorphosis into long-standing international disputes. Following years of states' interaction, it is now very well established that each member of the community of states, generally referred to as the international community, has in principle surrendered its primordial prerogative of self-help. With the strict exception of self-defense, the latter's legal refinement is also formidable. It is also widely admitted that states have voluntarily opted for the rule of law, especially when intending to or acting unilaterally. The majority of states, even the so-called mighty ones, and there are indeed serious indications, a few of them consider themselves all-powerful, if not almighty, usually cloak their quest for power, resources, and wealth under some well-formulated legal arguments based on the law as it stands. Still, one can easily identify other states who try to bully the community of states or other fellow states into doing, in most cases, not doing, i.e. not exercising their vested rights. While one can endlessly debate or feel inclined to, or even sympathetic about the former, no state easily accepts the latter. The most frequent example from the law of the sea comes from the law of the sea, namely international disputes arising from the use of particular maritime zones of a state's jurisdiction. This evening it is my intention to explore and analyse its vertex of the following equilateral triangle, namely rights and duties of states under the law of the sea, exploiting offshore resources by or on behalf of a state, and settlement of disputes in strict compliance with the rule of law. Ladies and gentlemen, 30 years are about to lapse since the adoption of the 1982 UN Convention on the Law of the Sea, whose negotiations lasted for approximately 8 years. The Convention is widely considered and generally perceived the outcome of a comprehensive and honourable compromise between the industrialized states and the so-called developing states. Both ends of spectrum reached an agreement on the powerful conception of property. With your permission, a preliminary remark. International law does not grant property rights to states. It simply defines the scope of their sovereignty. The raison d'etre of the regime was to secure for states exclusive control of the natural resources of the seabed and the sea wealth. While existing legal institutions back in 1982 were amended therewith, the most notable example is the breadth of the continental shelf zone, new zones of state jurisdiction were introduced. For example, the exclusive economic zone. The aim was to strike a fair balance between the freedom of the seas and the rights employed by the coastal state, especially those suffering from the systematic and widespread fisheries policy in the Pacific Ocean and the horrendous deterioration of their marine ecosystem taking place off their territorial waters. This legal instrument has attracted almost universal adherence and acceptance. Needless to indicate, the overwhelming majority of the Convention's provisions transcend their contractual utility and effect. That means that it is generally understood and has been equally held by the International Court of Justice and other international tribunals that they form part of general international law binding upon all states. In short, the coastal state, be that a wholly or partially mainland state or an island, is entitled to exploit and use its seabed wealth via the legal institution of the continental shelf. This is an inherent right of a state. It exists, as the court has held back in 1969, ipso facto et ab initio. Ergo, there is no legal necessity for the coastal state to express an intention and claim its own continental shelf. This is recognized by both the UN Laws Convention and general international law. There is, though, one principal limitation, namely the coastal state is prohibited from exercising any rights over the continental shelf in such a way that infringes or constitutes an unjustifiable interference with navigation and the rights of other states. The same cannot be said as per the exclusive economic zone, though its added value ought not to be underestimated. The EEZ mainly regulates fishing, exploitation of environmental friendly forms of energy production, winds, sea waves, kinetics. C, the right of the coastal state to construct offshore platforms and artificial islands, to carry out scientific research projects, and D, to protect and preserve marine environment. Here, the state has to declare publicly its intention to establish this zone of jurisdiction and exercise its sovereign rights thereto. If no declaration takes place, no right whatsoever will emerge. This is also recognized by both the Law of the Sea Convention and general international law. To offer a most useful example, back in 1986, Turkey and the then USSR finalized and fully agreed upon the delimitation of their respective zones, EEZ, exclusive economic zones, in the Black Sea, notwithstanding the fact that the former, i.e. Turkey, was not and still is not contractually bound by the Law of the Sea Convention. The very same applies with respect to the 2010 delimitation agreement of the maritime boundaries between Israel and Cyprus, where the former is not a signatory to the Laws Convention. Although utterly successful, the regime was never intended nor perceived as of an autopilot type. States are entrusted with a legal mechanism of fine-tuning in order to facilitate, preserve, and uphold their respective rights and claims vis-à-vis other states. For example, should an overlapping between the EEZs of two states exist, an international agreement based on international law must be reached between them in order to delimit their opposing or adjacent EEZs. The obligation of the state to delimit, whether the state is bound by the Laws Convention or not, forms again part of general international law due to the well-established and continuous practice of worldwide maritime delimitations. The starting point for a maritime delimitation of both zones is the so-called median line and the application of the principle of equidistance. Case law on the subject is adamant. Having said so, there are cases where the judiciary gave priority to the so-called special circumstances aiming at a fair and equitable solution. These circumstances include, inter alia, the configuration of the coastline, the length of the coastline, and the presence of islands. In some respects, the full effect of an island's right to use its continental self and/or its EEZ zone was seriously curtailed, if not diminished. Even bilateral delimitation scenarios are mindful of international community interests. Recent case law of the International Court of Justice has upheld its previous findings as per both the delimitation process and factors to be taken into consideration. In its recent maritime delimitation in the Black Sea judgment between Romania and the Ukraine, rendered in early February 2009, the court held, and I quote, "The coast of Serpent's Island," we're talking about a very small island, "is so short that it makes no real difference to the overall length of the relevant coasts of the parties." The court, in essence, eliminated this small island as a source of base points on Ukraine's coast, stating that to count Serpent's Island as a relevant part of the coast would amount to grafting an extraneous element onto Ukraine's coastline. Having heard so, the court distinguished the role of this island as a source of base points for measuring the breadth of the maritime zones from the possible role as a source of base points for constructing an equidistant boundary, eliminating any points on this very same island. Finally, the court reduced the importance of the island's potential role as a relevant circumstance or factor, calling for an adjustment to the provisional equidistance line, avoiding the question of whether the island was incapable of sustaining human habitation or economic life of its own. One can easily anticipate the legal effects of such judicial pronouncements in cases where islands form an integral, if not central, part of a state's socio-economic life and development. Ladies and gentlemen, in March 2010, the US Geological Survey estimated that the potential reserves of the Levant Basin cover up to 1.7 billion barrels of recoverable oil and 122 trillion cubic feet of recoverable gas. Cyprus has successfully delimited both its continental shelf and EEZ zone with some of its neighboring states, employing the principle of equidistance, and currently enjoys the fruits of this triumph. In 2007, Cyprus and Lebanon signed a maritime agreement which was ratified by Cyprus but not by Lebanon. In July and October 2010, Lebanon unilaterally declared maritime boundaries different from those prescribed in the 2007 agreement with Cyprus. Quite recently, a Lebanese delegation visited Nicosia, aiming at renegotiating the maritime boundary agreement. In December 2010, Israel and Cyprus concluded an agreement on the delimitation of their respective maritime zones of jurisdiction. By February 2011, this agreement was ratified by both parties. In June 2011, Lebanon protested against this agreement, for it considered that the defined zone absorbed parts of Lebanon's EEZ. Greece finally woke up. A new piece of legislation was enacted. It is now stipulated that in the absence of an international agreement with its neighboring states, the median line constitutes provisionally the outer borderline of the Greek maritime zones of jurisdiction. To this date, Greece has not declared its EEZ, ergo cannot claim any fishery zone, cannot protect efficiently its marine environment, and cannot take full advantage the unlimited and by all means clean energy provided by the sea currents and the wind. For reasons of fairness, one must state that in 1996, Greece finalized a first round of seismic concessions in several parts of Greece. Unfortunately, in 2000-2001, all concessionaires left Greece, and in 2007, all concessions were revoked, save the one at Prinos off Thasos Island. Quite recently, the Greek state has publicly acknowledged its lack of full and detailed knowledge in respect of the technical data of a seismic character. In order to tackle this diachronic shortcoming, an open procedure for public tender and novel concessions is announced in strict compliance with the applicable EU law. With your permission, I shall not enter into details, but I will try to answer any questions in the question and answer session. In any case, the nature and extent of any property system is largely at the discretion of the coastal state. Greece's fiscal and our current situation is well known. Notwithstanding its practice, which is premised on the assumption that foreign investments are more than desirable, endemic bureaucracy and corruption defeats any noble cause. It is common knowledge that an effective remedy to uphold state commitments will surely attract foreign investments. International commercial arbitration provides ample security with regard to state undertakings, while investment treaty arbitration encompasses a wider scope of contractual claims based on a flexible and open-ended notion of investment and a strong notion of the primacy of international law over municipal law. Both mechanisms are understood to contain a concrete and binding commitment from the state that specific expectations are to be honoured, and that these expectations have been relied on to make an investment. Still, one has to take into serious account a well-established legal limitation, namely the recognition of future expropriation, which both theory and practice consistently treated as an inalienable prerogative of the state. Practice also shows that bilateral investment treaties often establish an arbitration mechanism, a quite popular choice for future dispute resolution too. Bilateral investment treaties also aim at protecting an investor of one state locating assets in the territory of another state. The remedy provided for, usually through arbitration, is to ensure that the treatment of foreign investment is subject to the rule of law. Theory and practice identify 6 core principles, namely access, reasonableness, security, non-discrimination, transparency, and due process. At this point, I should clarify that any investment protection should not be pursued at the expense of other public policy objectives. It is in Greece's interest to promote a broad asset-based definition of the term investment, in accordance with the general practice of the states. After all, economies evolve. New forms of investment are created and acquire importance over time. Needless to indicate the obvious, i.e. that international investment law be extended also to domestic investors in order to avoid the creation of legal enclaves for foreign investors. Finally, the International Centre for Settlement of Investment Disputes, ICSID, is also at one's disposal. Its proceedings are free from the interference of local courts, save in cases when the litigants, by agreement, seek provisional measures from domestic fora. This, in my view, represents its main advantage for the Greek case, given that Greece has been repeatedly found by the European Court of Human Rights in violation of its treaty undertakings and obligations, especially under Article 6, Paragraph 1 of the European Convention, as per the time length of proceedings. Evidently, of grave importance is the pragmatism in the manner in which foreign investment is handled. The principal representative forms of foreign investment are the joint venture and the production sharing agreement. There is no need to deviate from established practice. A leading authority on the subject has rightfully pinpointed that the foreign investment should be given full protection and security. This standard has a firmer base in customary international law. Cases decided by exit tribunals in this area are also based firmly on precedents which existed in the past. What about the Aegean Sea, the eastern boundary of Greece and the western boundary of Cyprus? Is there a tension between predictability and flexibility when settling a maritime zone dispute? Our point of departure rests on the assumption that the legal title of coastal state is equal and has the same potential for generating jurisdiction over maritime zones. There is no discrimination between states, nor is there discrimination between coasts. Where Greek islands are located close to the coast of Turkey, a difficult question arises regarding their effect. The ICJ does not seem to attribute legal relevance to every circumstance invoked by the litigants. To my eyes, it appears that the case law is still fluid regarding the relation between the legal title and a method of delimitation, as well as an island's effect. At least three criteria have been suggested, namely, A, whether the circumstances in question do not run counter to the legal title of distance; B, whether the circumstances at issue produce geographically inequitable results when the equidistance method is resorted to; and C, whether the factors in issue affect rights over the maritime zones involved. Many maritime delimitation problems remain unresolved. State practice shows a constant recourse to ideas of equity or equitable principles. Moreover, if the equidistance method is applicable at the first stage of delimitation, the final line is surely determined by the consideration of relevant circumstances. This legal process has attracted the eulogy of the ICJ, or so it seems. Whether the maritime zones of Greece and Cyprus are overlapping to one another depends on the effect of the continental shelf and future Greek EEZ recognized to the Greek islands of Castellorizo and Strongili. To this day, Turkey has not challenged the 1932 delimitation between itself and Italy in the vicinity of Castellorizo, the latter state successor in the Deccanese being Greece. Turkey is unwilling to accept that Greece will, and Cyprus has, acquired sovereign rights in the Aegean Sea and in the eastern part of the Mediterranean Sea, respectively. The islands of Castellorizo, Rhodes, Carpathos, and Crete offer the needed baselines. Needless to underline, the islands of Castellorizo and Strongili, being the only parts of Greek territory opposing the Turkish shores, are entitled to their own maritime zones of Greek jurisdiction. In conclusion, I hold the view that Greece must sign an agreement delimiting the continental shelf and other maritime zones of jurisdiction with Cyprus, whereas an agreement tantamount to the foregoing concluded between Turkey and Egypt could only complicate the matter. Last Monday, the mainstream Turkish newspaper Sabah reported that Turkey seems to claim the entire region as if Cyprus and the Greek islands do not exist, and is willing to initiate negotiations for a delimitation with Egypt. Ladies and gentlemen, in September 2011, Turkey officially protested against the delimitation treaty between Cyprus and Lebanon. It also declared that the delimitation between Cyprus and Israel cannot be tolerated. In both cases, Turkey suggested that it shall use all necessary means in order to ensure the status quo and ordered a part of its fleet to initiate naval exercises in the high seas. No sound legal explanation was given as per its precise legal interest, especially with regard to the latter delimitation. The reaction of the EU, the United States of America, Israel, Cyprus, and Greece was very swift and quite sharp. The gunboat diplomacy approach forwarded by Turkey was utterly dismissed. The communiques issued were simply based on the customary character and principles of the law of the sea. On top of this, the Israeli Navy has been reported in maintaining a 24-hour watch presence in the region. A strong rhetoric of a different character altogether came from Lebanon vis-à-vis Israel. One has to admit that both states declared their determination to defend their respective resources and uphold the rule of law and international maritime law. Both states made it clear that they are fully committed to the law of the sea and presented their legal arguments, albeit in a minimal fashion. Undoubtedly, a legal dispute exists between the two neighboring states as per their rights in their respective maritime zones. States are under an obligation to recognize the correlative rights of other states and at least to consult with them as regards concurrent uses of transboundary resources. Bona fides negotiations must commence aiming at the conclusion of an interim agreement for delimitation. In addition, the UN interim force in Lebanon proposed to act as a mediator between the two states, Lebanon and Israel. It goes without saying that the dispute could be settled through arbitration or before the principal judicial body of the UN, the ICJ, or even the International Tribunal of the Law of the Sea, should both states decide to consent to it. Gunboat diplomacy is simply out of the question and can only lead to an unnecessary escalation. It is true that the United Nations Convention on the Law of the Sea provides little detail on what military conduct is allowed in different maritime zones or how this conduct, if allowed, is to be regulated. Nothing in the Convention can be construed as a replacement of the customary laws regulating the use of naval force under the UN Charter. Arguably, state practice leans in favor of the legality of military activities in the EEZ, subject to a due regard requirement. It has been suggested that the want of precision as to what military activities are permissible on the high seas and in the EEZ may constitute good reason to allow for third-party dispute resolution. Both systematic and spontaneous tension form the bread and butter of the UN Security Council's daily business. The Security Council has employed a unique self-restraint, if not self-discipline, when examining international incidents relating to threats to peace. There is a remarkable consistency between the words and its deeds. The Security Council does not depart or even deviate from the corpus of its previous decisions and methodology. In short, it has ensured political and legal certainty. Quite recently, the Security Council decided that illegal exploitation of natural resources and illicit commercial transactions thereto fall well into the ambit and constitute a threat to peace. On a second reading, to my mind, of a more groundbreaking approach, the Security Council expressly recognized in two quite distinct incidents that the non-substantial consolidation of the rule of law within the state itself triggers a chain reaction and establishes a situation falling directly within the ambit of a threat to peace. Until 2009, UN Security Council settled practice and language were formed on the perception that its decisions were mainly, if not exhaustively, of a political, extra-legal or paralegal character. For the first time, it was clearly stated that where the rule of law ends, threats to peace commence. Having said so, I put before you that when acting under Chapter 7 of the UN Charter, the Security Council must embark upon a preliminary, clearly legal appreciation and classification as per the necessity, the type, the time, and qualitative breadth and the seriousness of the alleged rule of law violation. An automated, presumably arbitrary, and of a strictly political type nature decision is not satisfactory anymore. Should the instructive role of the rule of law, especially in the domain of Chapter 7 of the UN Charter, is acknowledged, the indeed wide discretionary powers enjoyed by the UN Security Council are curtailed. What an achievement will it be when the community of states is convinced that the whole UN system systematically upholds the advantage of legal certainty. In my opinion, states have come closer to a more challenging and widely positivistic approach when invoking the rule of law. The arti legis content of the phrase threat to peace may create problems, for it was intended and it is undoubtedly broad. Taking into account the practice of the UN Security Council, especially during the last decade, and the corresponding state practice, it is my profound belief that an international custom is about to emerge as per its frame and its substance. Whether a double standard approach will prevail is the wiser gamble. Consequently, the safest way out when collectively dealing with threat to peace crisis is offered by the strict observance of the rule of law in the international arena. In 1933, Sir Herz Lauterbach expressed the view that, quote, within the community of nations, this essential feature of the rule of law is constantly put in jeopardy by the conception of the sovereignty of states, which deduces the binding force of international law exclusively from the will of each individual member of the international community. In fact, the view that the prerogatives of states do not imply an unrestricted and indiscriminate use of formal rights has been expressed by many international lawyers of distinction. Some 77 years following Sir Herz's thoughts, in 2010, Lord Tom Bingham drew the sword in defense of the rule of law in the international arena. He suggested that however attractive it might be for a single state to be free of the legal constraints that bind all other states, those states are unlikely to tolerate such a situation for very long, and in the meantime, the solo state would lose the benefits and protections that international agreement can confer. The rule of the jungle is no more tolerable in a big jungle. Thank you very much.